Right. With that said, let's talk about our program for today. We're talking about the Health Insurance Portability and Accountability Act, or HIPAA. The HIPAA's codified the rules that we talk about today in 45 CFR Part 164. The security rule is in point 300, the privacy rule is in point 500, and the breach notification rule is in point 400. Talk briefly about HIPAA penalties. Why do you need to take this stuff seriously? Well, you can go to jail for HIPAA violations if you or your employees, if you obtain or disclose protected health information from a covered entity without violation. You can get hit up with penalties of anywhere from $50,000 to $250,000. Plus, you can go to jail for anywhere from 1 year to 10 years in prison. People have gone to jail for HIPAA violations. Most often, though, you're concerned about the civil penalties. As we've talked about in our other programs, the penalties can range from anywhere from $100 to $50,000 per violation. Now, the scary part is if you act with willful neglect, it is a mandatory fine of at least $10,000 to $50,000 per violation. That's if you correct it within 50 days, it's a mandatory fine of $10,000. If you fail to correct it within 30 days, it's a mandatory fine of at least $50,000 per violation. The government was concerned that the Office for Civil Rights was not actively enforcing HIPAA, and therefore, if you act with willful neglect, they've told the OCR that they must impose this mandatory penalty. That's the bad news. The good news is, if you did not act with willful neglect and you correct the situation within 30 days, then you can avoid HIPAA penalties. That is an affirmative defense to HIPAA penalties. That's why it's so important that you act as soon as you receive word of a potential HIPAA violation. You want to correct it within the 30 days so that you can avoid these penalties. And you definitely do not want to act with willful neglect. What does willful neglect mean? Willful neglect means the conscious, intentional failure or reckless indifference to the obligation to comply with the HIPAA rule that was violated. So you knew you were supposed to comply, or you should have known you were supposed to comply, and you just didn't do it anyway. For purposes of our discussion today, the following content from the government, the commentary from the government, is helpful. They gave this example of willful neglect. A covered entity's employee lost an unencrypted laptop that contained unsecured protected health information. That is not a good thing. HHS's investigation reveals that the covered entity feared its reputation would be harmed if the information about the incident became public, and therefore decided not to provide notification as required by the breach notification rule that we're going to talk about a little bit later. That would constitute willful neglect. That means that the government would have to impose a penalty of at least $10,000 per violation. And by the way, every patient's information who is on that laptop, that could be a separate HIPAA violation. That's how you get these big ticket violations. The key here is to remember that, look, even though you may have a breach, that breach, the initial breach, may not be willful neglect. You may be able to avoid penalties because you didn't do anything wrong. And sometimes things just happen. On the other hand, once that occurs, if you hide it, then that may be willful neglect, and you may be subject to those penalties. So it's very important that when you believe that you have a potential HIPAA violation, that you respond immediately and take appropriate steps. Up on the screen, there's a few of the penalties that have been assessed or settlements that have been reached with entities for HIPAA violations lately. Those two that are in red were particularly of interest to me. These came out just real recently in the last few months. The key here is that both of those involve situations where violations occurred, but the OCR imposed these bigger penalties because the covered entities failed to respond appropriately. They failed to take appropriate steps and correct the situation, either that it was ongoing problems for a long period of time and they just kind of hid their head in the sand and didn't do anything about it, or in other situations, they knew that there was a violation, but they failed to timely report breaches. We had the first case against an entity for failing to timely report breaches within the 60-day period as required under the HIPAA breach notification rule that we'll talk about a little bit later. That entity got hit up with $475,000 based on its failure to do the timely report. So the key to remember here, the key to avoiding HIPAA penalties, You need to make sure that you implement the required policies and safeguards in advance, and you train your personnel and document that training. And if there is a problem, you respond promptly and appropriately to the suspected violations. If you do that, I can almost guarantee you that you can avoid willful neglect penalties. On the other hand, if you fail to do that stuff, then there's a good chance you could get hit up with willful neglect penalties under HIPAA. You could face those fines and penalties, in addition to facing all of the additional costs in responding to breaches, potential privacy lawsuits, and things like that. So it's really important that you take HIPAA seriously, respond or act appropriately at the get-go, and respond appropriately if you think that you may have a problem. So what do? If you think that you have a problem, you're sitting at your desk, suddenly somebody rushes in and says, oh my gosh, we just think that we had this HIPAA breach. What do? Well, here's my quick steps. Again, don't do this. Don't hide your head in the sand. Remember, just like that person who lost the laptop, the government said, if you ignore your responsibilities, that could be willful neglect and subject you to those mandatory fines and penalties. So the first thing you want to do is take immediate steps to stop any ongoing breach. You plug the dam. If you've got something that's sending out wrong patient information, or you posted wrong patient information on your website or things like that, you want to take immediate action in order to take that off, stop the breach, stop the bleeding, make sure that there's nothing else going out. We'll talk more about that in just a minute. Next, you want to train your people to immediately report the incident to your privacy officer and or security officer. Every one of you who is a covered entity must have a person designated in writing as the privacy officer and or security officer. Those are your internal HIPAA gurus. They are the people who are supposed to handle HIPAA breaches. You want to train your people to respond immediately if there's a potential violation. Why? Well, an immediate response, if you jump on this, you may be able to mitigate the damages and avoid breach reporting obligation and or penalties. For example, you may be able to avoid penalties if you correct the violation within 30 days of when you knew or should have known of the violation. If you don't know of the violation, everybody else in your office knows about it, but nobody thought to tell you about it, so you couldn't act on it, well, if you don't find out about it until 45 days after, you may be too late to get the benefit of that 30-day time limit. In addition, under the HIPAA breach notification rule, you have an affirmative obligation to report the breach to the covered entity and HHS. Well, to the covered entity at least, HHS sometimes, within 60 days after you knew or should have known of the potential violation, the reportable breach. Now, that 60-day time period begins to run not from when the privacy officer learned about this. That 60-day time period begins to run when anybody in the organization knew about it other than the person who committed the breach. And so you want to train your people to come to you immediately so that you can jump on this potential violation so that you can mitigate your damages. Generally, I recommend that it's the privacy officer who investigates these breaches. You want somebody who knows the law and can respond appropriately. As part of that, the first thing that privacy officer is going to want to do is make sure, hey, does HIPAA even apply to this situation? Remember, HIPAA doesn't apply to all privacy breaches. It only applies to breaches involving protected health information that an entity maintains in its capacity as either a health care provider who engages in certain electronic transactions, or a health plan, including employee group health plans with 50 or more participants or administered by a third party. Those are the covered entities under HIPAA. In addition, in the wake of the omnibus rule, HIPAA also applies directly to business associates of the covered entity. So if that breach is by a covered entity or a business associate, then potentially HIPAA applies. But it also has to involve protected health information. So ask yourself, did the breach involve protected health information? What's protected health information? Well, it's information that's created or received by, most often, a healthcare provider or a health plan acting in their capacity as such. So if you're a healthcare provider, you're a hospital, you're a group practice, and you lose patient data, well, that's going to implicate HIPAA. On the other hand, If you lose employee information, well, employee information is generally not protected by HIPAA unless it's employee group health plan information. If it's just employee information, then you may have a privacy breach, but it's not going to be affected by HIPAA. So make sure that you look and see whether or not HIPAA really applies. Again, it applies to any protected health information created or received by a healthcare provider or health plan and relates to the past, present, or future healthcare, or payment for the healthcare. And it's individually identifiable, meaning that it identifies the individual or there is a reasonable basis to believe that the information can be used to identify the individual. Now, if you've gone in and sucked all the identifying information out of it and de-identified the information, then it's no longer covered by HIPAA. And if that's the case, then you really don't have a breach reporting obligation under HIPAA. You may have obligations under state laws, but HIPAA would not be implicated if there is a breach of de-identified information. You just need to make sure you've really sucked out all the identifying information. Next, once you've confirmed that, yes, okay, it involves a covered entity or business associate, yes, it involves protected health information, was there really a HIPAA violation? Because at least under the breach notification rules, you only have to provide the required notice if there's a breach of the privacy rule. Well, what does that mean? Remember, the privacy rule in general says the following. It says you cannot use, access, or disclose protected health information unless you fit within a HIPAA exception. What are the HIPAA exceptions? Well, if that use or disclosure was for purposes of treatment, payment, or healthcare operations, generally, that's not a HIPAA violation, so long as the disclosure or use was for purposes of treatment, payment, or healthcare operations. That's so long as you did not agree otherwise with the patient. HIPAA allows you to use or disclose protected health information for purposes of treatment, payment, or most healthcare operations without the patient's authorization. But HIPAA also says, hey, if you're really into privacy, you agree with the patient to impose additional restrictions on your use or disclosure of protected health information. For example, you tell the patient, hey, we won't disclose this information to a third party unless you authorize us. Well, if that's the case, then you've got to abide by that, even if that disclosure is for purposes of treatment, payment, or healthcare operations. The second exception is you can use or disclose information for use of a facility directory, certain information anyway, or you can make certain disclosures to family members or persons involved in the patient's health care or payment for their health care so long as the patient didn't object and you satisfy certain other criteria. We talked about that a couple of weeks ago. The next exception is if you have a valid written HIPAA-compliant authorization that satisfies the requirements under the rule, or you have a written patient request to provide the information, even though it doesn't satisfy the HIPAA authorization rules. And in the wake of the omnibus rule, they created a new exception that allows you to make disclosures, and not only allows you, but requires you to make disclosures if you get the patient's written request to make the disclosure to a specific individual. Finally, there are a series of exceptions that allow you to make disclosures. For example, if the disclosure is required by another law or satisfies another exception. Most of those are for certain public safety or government functions like certain reportable offenses, disclosures to the police if you satisfy certain criteria. So the bottom line here is before you just jump to the conclusion and think that there's a breach, you have to do the analysis and conclude, okay, was there really a violation of the privacy rule, or was this use or disclosure actually permitted under the privacy rule? Remember, the breaches include acts by business associates and your agents of a covered entity. So you not only have to be concerned about your own breaches, but you also have to be concerned about responding appropriately to breaches by your business associates. HIPAA also has what's called the minimum necessary standard. You can have a reportable breach, even though HIPAA allows the disclosure if you disclose more than is minimally necessary. That's still a violation of the privacy rule and can result in a reportable breach. So make sure that you understand the scope of the minimum necessary rule and you're not disclosing more than is minimally necessary. Remember that when you're determining whether or not there's a reportable breach, that incidental disclosures do not violate HIPAA and are not reportable. Well, what are incidental disclosures? Incidental disclosures are those disclosures that are incident to a use or disclosure that is otherwise permitted or required and the covered entity otherwise complied with the minimum necessary standard and implemented reasonable safeguards to protect against the improper disclosures. It's like when you're walking down the hospital, you may overhear a nurse say something. And as long as the hospital had reasonable safeguards in place and that disclosure was incidental to another permitted use, you know, the nurse was reporting something to the doctor and you just happened to walk by and hear something, as long as the hospital had reasonable safeguards in place, then that is an incidental disclosure. It is not a breach and it is not reportable. Again, from OCR, an incidental use or disclosure is a secondary use or disclosure that cannot reasonably be prevented, is limited in nature, and that occurs as a result of another use or disclosure that is permitted by the rule. For example, a hospital visitor may overhear a provider's confidential conversation, or a hospital visitor may glimpse a patient's protected health information on a sign-in sheet or nursing station whiteboard. The key there is that you've put in place reasonable safeguards to avoid disclosures. And if you do, and something just happens, that they happen to hear something, but you took reasonable steps, then that's generally an incidental disclosure and not reportable. All right, so that's the fourth thing you do. You want to make sure and determine whether or not HIPAA even applies to that. The next thing, you're going to want to investigate promptly to determine the scope of the investigation. Determine the facts related to the proposed or the possible breach. Confirm the facts with the persons who are involved, not only the person who committed the alleged violation, but also persons who may have received the information improperly. Confirm whether or not they really did get information, along with any other witnesses to the proposed violation. You'll want to talk with the person who committed the violation or alleged violation to confirm the reason for the use or disclosure. Again, there's lots of situations under HIPAA where the use or disclosure is actually permitted, and I've had situations where privacy officers have concluded, oh yeah, there's a breach, but once I did the interviews, once I investigated, I concluded no. It was a use or disclosure that was permitted by the rules and there was no breach. Confirm what information was accessed, used, or disclosed. How much information was really used or disclosed? The scope of the access, use, or disclosure. Was it just one isolated record? Was it a USB containing hundreds of patients' names? Was it something that was posted out there on the internet? And if it was posted out there on the internet, can you identify how many people may have viewed that? How many clicks there were to access that? Confirm that no further access, use, or disclosure was made. When you're talking to the persons who received this, identify, okay, you got some information. You didn't disclose it to anybody else, right? Or if they did disclose it, find out where else that information went, because you may have an obligation to track that down and contact those people to stop further uses or disclosures of that particular information. Next, determine what steps should be taken to mitigate or correct the situation. We'll talk about that more in just a minute. And make sure that you document the scope of the investigation that you conducted, including who you talked to, what they said, especially the scope of the breach and that no further breach occurred. When you're doing that investigation, don't make matters worse by disclosing protected health information during the course of your investigation. Remember, you're there to get information, not give information. By all means, for heaven's sakes, don't make matters worse by talking to the person, oh, did you get information about patient X that indicated she was pregnant? Don't do that. You can ask, it was reported that you may have received information. Can you tell us what it was, who it pertained to? Receive information, don't give information. It's a one-way street when you're doing that investigation. Next, once you've done that investigation or as part of that process, you need to take immediate steps to mitigate any harm. That is a specific requirement under 45 CFR 164.530. The covered entity must mitigate to the extent practicable any harmful effect that is known to the covered entity of a use or disclosure by the covered entity or its business associate of the information in violation of its policies or privacy rule. Under the, if you know that your business associate is out there messing up and violating, then you have an affirmative obligation to make sure that that business associate stops. And if the business associate fails to stop or can't stop, you have an affirmative obligation to terminate your business associate agreement. Per our discussion last week, that's one of the terms you have to make sure that it's inside your business associate agreement. What are some steps to mitigate the harm? What are the types of things you can or should do? Well, certainly you want to stop any further breaches. If something's posted on your website, take it down. If some fax was sent out there, then you contact the person who received the fax and you retrieve it, or can make sure that it's been completely destroyed and won't be used. If information's out there someplace, to the extent you can, you should delete it. You should contact the recipients to confirm the scope of their uses or disclosures, and as part of this, warn them against future uses and disclosures. I think this is particularly important. I think it's very helpful that if you learn that somebody received information improperly, that you contact them and as part of the investigation, find out what information they received and warn them that, hey, we really appreciate you letting us know about this information. Just so you know, this information is protected by HIPAA. And if you further use or disclose this information, you can be liable for those criminal penalties I referenced earlier that can be horrendous. I usually follow that up with a letter to the person. Depending on the situation, it can be an appropriate letter that just says, hey, thanks for speaking with me, really appreciate you talking with me. This confirms that you have not further used or disclosed the information, and you will not further use or disclose the information. You have returned all the information and or completely destroyed the information so that it is not, cannot be accessed, will not be accessed. And by the way, if you should attempt to use or disclose that information improperly, then you can be subject to these penalties. I like sending that letter and documenting it because if the government ever comes back, I want to be able to show that we took appropriate steps to mitigate any harmful effects, including warning those people of those problems. You want to terminate access, change passwords, etc. if you think somebody's accessing the information improperly or may have gotten a password. Really important if you can. When you go back and you look at all those penalties that have been imposed, the $1 million penalties, the hundreds of thousands of dollars, almost invariably those involve the loss or theft of unencrypted devices, mobile devices, laptops, those things. To the extent you can, you certainly, well, even if you can, you certainly want to encrypt data on that. And to the extent that you can, you may want to install software that will allow you to do remote wipes. If you can do that, then that's an appropriate steps to take to mitigate your potential damages in the event of a loss or of a laptop or things like that. You may want to notify the affected individuals of the breach. We'll talk about that later. You maybe want to cover the cost of additional measures to protect the patient, such as credit reporting if it was a significant breach and that person's identity may be subject to theft. But unlike some people believe, there is nothing in HIPAA that says you must put in place these credit reporting plans or programs. It is a common step to mitigate, but it is not necessarily required by HIPAA. But you want to think about what are the appropriate steps that you should put in place to mitigate. And of course, you're going to want to document your actions, both in your HIPAA investigation file and in letters to persons who are involved, confirming the facts and the warnings that I mentioned. Next, you're going to want to sanction employees who are involved in this, who are engaged in any kind of wrongdoing. HIPAA specifically requires, as one of the requirements under the privacy rule, that you have an affirmative obligation to sanction employees for HIPAA violations. Now, what kind of sanctions must you put in place? Well, it doesn't necessarily mean you fire them out of the box. You may, but you're going to want to make sure that you structure that sanction to fit the crime. It could just be a written warning if it was a relatively innocuous problem or a first-time offense. If it's not, if it's more serious or a repeated offense, it could be suspension or mandatory HIPAA training, maybe termination from employment, possible report for government action, turn your own employee in order to protect yourself. Those are some things that you can do. The key there is to make sure that you document your sanctions, that the sanctions are appropriate, and that you're taking appropriate steps that are going to correct the situation going forward. The sanctions may depend upon the intent of the person, the seriousness of the breach, was it repeated misconduct or a first-time offense, and any other relevant factors. When you're imposing those penalties, you're going to want to look at your own employee policies, make sure that your actions from an employment law perspective are consistent with your employment policies, but you do need to take appropriate action and sanction employees for violations of HIPAA. Next, you need to make sure that you correct the violation. As I mentioned, it's an affirmative defense to HIPAA penalties if the covered entity did not act with willful neglect and you correct the violation within 30 days. I cannot overstress the importance of doing this. Now, you may be thinking, well, wait a minute. How can we correct that situation? We send out the fax. The person already got the fax, the wrong person. They read it. How can we unring the bell? Well, the government acknowledges that, okay, you may not be able to make it all right again, but there are steps you can take to correct the situation, even in that situation. The government indicates that they interpret correction broadly. For example, they stated, in the event a covered entity's or business associate's non-compliant inadequate safeguards or policies result in an impermissible disclosure, the disclosure violation itself could not be fully undone or corrected, but the safeguards violation, however, could be corrected in the sense that the non-compliant policies and procedures could be brought into compliance. Even though you can't unring the bell, you can correct the situation by, for example, retrieving the information, taking steps to mitigate the harm, by sanctioning employees, by revising your policies and procedures or implementing new or different safeguards, training your personnel, and document your training. So if you have a violation, make sure that you use that as an opportunity to train your other personnel about that to make sure that it doesn't recur. You need to enforce your policies and rules, maybe notify affected individuals. Again, we'll talk about that later. Take any other appropriate steps that you feel are necessary in order to correct the violation or mitigate the violation. And, of course, document your actions. In this process, as you're going along, if it's a serious violation, then you may want to consider checking your insurance. Most of you, hopefully, have some form of cybersecurity or breach notification insurance. Sometimes that appears either as a rider in a particular policy, or in some situations, if you've got a broad business policy, some courts have interpreted those business policies to actually extend to lawsuits that are brought based on breach violations and the like. The bottom line is if you have a significant breach, you may want to check your insurance to see whether or not you've got coverage. You may also, even if you don't think you have coverage, contact your broker or your agent and report the claim anyway, tender the claim to them, because it may be that they accept coverage even if you think that there isn't coverage. You're never in a worse position for at least tendering that claim to them. Make sure that you don't provide them with any protected health information. If you do provide them with protected health information, make sure you get a business associate agreement with them first. One thing you'd ought to do, if you haven't done so recently, you'd really ought to go back to your organization and just confirm the scope of your cyber liability insurance. As we talked about last week, as Matt's going to talk about next month, healthcare entities are huge targets right now for cyber attacks. They are one of the prime targets, and it's really important that you take cyber liability seriously. To that extent, you may want to have cyber liability insurance or cyber attack insurance so that you can protect your data. Make sure that you document your communications with the insurer if there ever is a coverage dispute down the road. If you can show that you tendered that or the insurer accepted coverage, you can document all of that stuff, then the insurer may be stopped from denying coverage even if there really is no coverage. Next, you're going to need to log improper disclosures. Now, this is different than your breach reporting under the breach reporting rule. Remember, under the HIPAA privacy rule, 45 CFR 164.528, a patient has a right to request an accounting of certain disclosures of their protected health information made by a covered entity or business associate during the prior 6 years. That is not all disclosures that you've made. It's generally only those disclosures in violation of the HIPAA rule and disclosures for certain government functions under 45 CFR 164.512, like disclosures to law enforcement, disclosures to to the Board of Medicine if they happen to show up, those types of things. You will have to log those. Now, that doesn't mean you have to turn those over to the patient right away. You only have to log those, so if the patient comes in and requests for the accounting disclosure, you've got that available. Remember that this only requires you to log the improper disclosures. Disclosures are the release, transfer, provision of access to, or divulging in any other manner of information outside the entity holding the information. So if you've got an improper access internally, that's probably not going to need to be logged. We're talking about the disclosure outside your organization. When you do that accounting log, when you maintain that, you're going to have to log the information concerning the following disclosures: the date of the disclosure, the name and address of the entity who received the information, a brief description of the information disclosed, a brief statement of the purpose of the disclosure, or a copy of the written request for disclosure. As a practical matter, that's going to require you and your business associates to maintain that log of disclosures. I suppose what you could do is not maintain that log, but when the patient shows up and requests the accounting, how in the world are you going to be able to remember all the disclosures that you've made? As a practical matter, you generally got to maintain that log as you're going along. Under the HITECH Act, the HITECH Act would have actually expanded this accounting of disclosure requirements to not only cover these improper disclosures, but also require those entities that have electronic medical records to be able to generate a report that identifies other disclosures. In a proposed rule that was issued by HHS, this proposed rule would have actually required those entities with an electronic medical record to generate a report that identifies all access or disclosures for treatment, payment, or healthcare operations and other access. It was very burdensome, and it met with a lot of resistance when the proposed rule came out. That proposed rule has never been finalized, and in the era of the Trump administration, I'm not sure it will ever be finalized. The HITECH Act is still in place, but because we don't have the implementing regulations, I guess I'm not too worried about complying with the requirements. I haven't seen anybody get tagged for failing to make that electronic report required by the HITECH Act. Until we get those regulations, knock on wood, I doubt that you're going to get cited if you're not complying with those HITECH Act requirements. But one never knows. Next, assuming that you've got a reportable violation and you're a business associate, that business associate has certain reporting obligations back to the covered entity. That business associate has to, under HIPAA and also the terms of the business associate agreement, it's got to report any use or disclosure of protected health information that was not provided for by the business associate agreement of which it becomes aware. Now think about that for just a moment. This requirement doesn't just mean that you have to, if you're a business associate, you have to report violations or breaches in violation of HIPAA or breaches that are reportable to the government. You have to report any use or disclosure of information that's not allowed by the business associate agreement of which you become aware. Even if the breach didn't violate HIPAA, if your use or disclosure is outside the scope of what you are permitted to do with that data, then you've got to report that to the covered entity even though it didn't violate HIPAA. If you fail to do that, fail to make that report, then that's a violation of HIPAA, as well as your business associate agreement obligations. In addition, under the security rule, you have business associates have an affirmative obligation to notify the covered entity of any security incident of which it becomes aware. Now, security incident is defined as the attempted or successful unauthorized access, use, disclosure, modification, or destruction of information or interference with system operations in an information system. Note that it's not only the successful unauthorized access or use, it is the attempted unauthorized access or use. Well, wait a minute, like we talked about last time, what does that mean? I mean, every time I'm subject to pings or port scans or things like that, even though they are not successful, I've got to report that. Well, if they constitute a security incident here, they're an attempt to access it, even if it's unsuccessful, then yes, under the security rule, the business associate is required to make that report to the covered entity. Under the guidance that the government issued, though, in cloud computing that I talked about last time, the government has suggested that you can come up with the appropriate methodology for making that report. You don't necessarily have to do a daily report identifying all your pings. You could do a monthly report or some other process for making those types of reports. You just want to look at your business associate agreements and make sure that you've addressed that particular situation. And finally, of course, the business associate has to report to the covered entity if that business associate is aware of breaches of unsecured protected health information that are covered by the breach notification rule. So just quickly in summary, what does the business associate have to disclose or notify when they have to notify the covered entity? If there's any use or disclosure of information that's not allowed by the business associate agreement, even if it doesn't violate HIPAA, they've also got to notify them of security incidents, and they've got to notify them of breaches of unsecured protected health information under the breach notification rule. Your business associate agreements, you may want to go back and take a look at those, particularly if you're a business associate, because they may have additional requirements dealing with breach notification. This is the stuff that's required by HIPAA, but business associate agreements may have additional requirements, including the timing of the notice that has to be given, who you give the notice to, things like that. All right, number 12, the next thing you need to do is you've got to make sure that you report the breach per the breach notification rule if it is required. The breach notification rule states that if there is a breach of unsecured protected health information, the covered entity must notify each individual whose unsecured protected health information has been or is reasonably believed to have been accessed, acquired, used, or disclosed. So you got to tell the individuals who are affected. In addition, every time you notify the individual, you are also going to have to notify HHS, the federal government. And you're going to have to notify local media, but only if the breach involves more than 500 persons in a particular state. We'll talk about that more in a minute. In addition, if you're a business associate, the business associate must notify the covered entity so that the covered entity then can give those notifications that it's required to do. Note that the breach notification rule turns on two important terms. First, you only have to do the breach notification under this rule if there is a breach of unsecured protected health information. Let's talk briefly about each of those. What is unsecured protected health information? Well, it's information that's not secured. So what's secured protected health information? Well, right now there's currently only two methods to secure your protected health information. One is if it is electronic data, you got to encrypt it, and the encryption has to satisfy federal standards. If it is not electronic data, then it's, well, I guess it could be electronic data, but the other way to secure the information is to completely destroy the protected health information so it can never be used or viewed again. I always thought that was kind of curious because if the information was completely destroyed, how in the world did anybody access it anyway? But that's the only way that you can secure your protected health information. As a practical matter, the only type of secure protected health information is really just encrypted, properly encrypted electronic data. Everything else is unsecured protected health information. Then the question is, okay, we've got unsecured protected health information. Was there a breach? Well, what is a breach for purposes of the breach notification rule? A breach is the acquisition, access, use, or disclosure of protected health information in violation of the privacy rules. Note, it's in violation of the privacy rule, not the security rule. The breach notification rule is only triggered if there's a violation of the privacy rule, and that the unauthorized access, use, or disclosure of protected health information in violation of the privacy rule is presumed to be a reportable breach unless the covered entity or business associate can demonstrate that there is a low probability that the information has been compromised. How do you determine that? Well, it's based on a risk assessment of the following four factors: the nature and the extent of the information involved, the unauthorized person who used to receive the information, whether the information was actually acquired or viewed, and the extent to which the risk to the information has been mitigated, unless an exception applies. What are the exceptions? The breach notification rule says that the following do not constitute a breach: the unintentional acquisition, access, or use by a workforce member if it's made in good faith within the scope of their authority, and no further disclosure in violation of HIPAA. What does that mean? Maybe you've got a nurse that's going in there and looking for patient John Smith. She calls up patient John Smith's information only to learn that, oh my goodness, I looked at the wrong John Smith. Well, that is the unintentional acquisition access or use by a workforce member. As long as she does not further disclose that to somebody else, the information that she gained about the wrong John Smith, then that is not a breach. It's not reportable. Probably an incidental disclosure. You don't have to worry about that. Similarly, a breach does not include the inadvertent disclosure by an authorized person to another authorized person of the same covered entity, so long as there's not a further improper disclosure. This is the situation where a nurse comes up to the physician and says, "Doctor, I see that you are treating John Smith. This is what's going on with John Smith." After she talks for 5 minutes, they finally realize they're talking about the wrong John Smith. In that situation, there has been the unauthorized or inadvertent disclosure of information, but as long as they don't further disclose that information, that improper information, then there is no breach for purposes of HIPAA. Finally, this is the one that I think is the most interesting. It is not a breach if the disclosure of PHI where the covered entity or business associate have a good faith belief that the unauthorized person receiving the information would not reasonably be able to retain the information. Well, what does that mean? Does that mean if the person who receives the information has a very bad memory, that suddenly that's not a breach? Well, I don't think so. When you look at the commentary, they give the following examples. The nurse goes out, has the discharge instructions, goes up to the patient, hands them to the patient only to immediately realize that, oh my goodness, this is the wrong patient. She immediately takes that information back before that patient had a chance to really see or digest or get any of the information. In that situation, that would not be a breach. They give you also an example of maybe you send out your explanation of benefits. You send a bunch of those out, and a bunch of them are returned unopened. They've gone to the wrong address or the patient's no longer there. But if they were unopened, you may conclude that the person who received it would not be able to retain the information. In that situation, you can conclude that there was no reportable breach. Those don't occur, well, they may occur very often, but those aren't the ones that really concern us. So we're really dealing with your garden variety breach. You sent the wrong facts to the wrong person. You've got an employee who's snooping or out there talking to other people. What do you do about those? Well, the question is then, has that information been compromised? The question has come up, well, does compromise mean that the information is acquired, accessed, used, or disclosed? Every time you've got information that's accessed or disclosed, doesn't that mean that the information is per se compromised? Well, we really don't know what compromised is other than this analysis. They don't define what compromised means, but they do indicate in the commentary that, look at, there's some uses or disclosures that are just so trivial that you can just assume that there's a low probability that the data is compromised, and that the burden of making the disclosure would be so great, both on you or the person who receives that, would receive that disclosure, that it's simply not worth doing it. HHS noted there are situations in which the unauthorized acquisition, access, use, or disclosure of information is so inconsequential that it does not warrant notification. So what do we know about that risk assessment? Well, these are the factors that you've got to determine whether or not that information, there's a low probability that that has been compromised so as to trigger the breach notification rule. These are the 4 factors. The first is the nature and extent of the information involved, including the types of identifiers and the likelihood of re-identification. Did you just simply send facts that indicates that this person's a patient, but no other information? Or did you send the information, the facts that also contains the patient's social security number or all their labs or the diagnosis? That is one factor. The second factor, who was the person who received the information? Did it go to another doctor's office who knows that they're supposed to keep the information confidential? Or did it go to the Russian mafia who's down on the corner? The identity of the person who received the information, that's an important factor. Number 3, whether the information was actually acquired or viewed. Note that this is just one factor. The fact that the person didn't actually view the information is a factor, but not the sole factor. I think that's kind of an interesting one. Now, the 4th factor, the extent to which the risk to the information has been mitigated. If there was an improper disclosure, but you jumped on it immediately, you realized that fax went to the wrong entity, you immediately called up that other doctor's office, and that doctor's office says, oh yeah, we just got the fax, but I haven't looked at it. Okay, I'm tearing it up. I'm completely destroying it right now. No, I haven't looked at it, and nobody else has looked at it. Well, in that situation, you may conclude that you have mitigated the risk and that there's a low probability that the data has been compromised. Finally, the government has said that there are other factors as appropriate that you may consider, but it's those first four that they require you to consider as part of your risk assessment. Now, it may be that you just are going to go ahead and timely make the report no matter what. If that's the case, you don't have to do the risk assessment. On the other hand, if you're thinking about not doing the report, then you're going to want to document that you performed an appropriate risk assessment. What kind of guidance have we got in assessing those elements, those risk assessments? We haven't got a whole lot. But in the commentary that came out in the breach notification rule, as well as the omnibus rule, the government has given us some kinds of keys, some tidbits. For example, based on the commentary, the following situations likely involve a lower probability that the information would be compromised. Not necessarily it's not reportable, but this suggests that there's a lower probability. You have a fax that's sent to the wrong physician, but the physician reports the fax and confirms he has destroyed it. Well, it went to a person who's covered by HIPAA anyway, probably a low probability. Along those lines, the government said if the disclosure is to a use or persons who are otherwise required by HIPAA to maintain confidentiality, probably a lower probability that the data is compromised. Disclosure without identifiers or to an entity that lacks the ability to re-identify the information. So you send out a document that's got the patient's record identification number on it, but no other identifiable information. The person who receives it can't link that identifier to a particular patient. Low probability the data has been compromised. You have a stolen laptop, and it's recovered in the analysis. You do a forensic analysis, and it shows that the information was not accessed. In that situation, you could probably conclude there's a low probability the data has been compromised. But the government's careful. They say you really need to look at all of the factors. Not one factor is dispositive. You need to look at all the relevant factors. On the other hand, the government has said that the following situations likely create a higher likelihood that the data has been compromised. If the disclosure involves financial data like credit card numbers, social security number, etc., or sensitive information like STDs, mental health, or other information, or even if the information is not all that sensitive, but it's fairly extensive or detailed, like treatment plans, diagnosis, medication, medical history, test results, those factors suggest that there's a higher probability that the data is compromised. Next, did the disclosure involve a list of patient names, addresses, hospital IDs, or was the information mailed to the wrong individual who opened and read it, but the person's not a covered entity or business associate? If they're not covered by HIPAA, that creates a higher probability that the data is compromised, and therefore there's likely going to be a reportable breach. But again, you've got to evaluate all of the factors. When the omnibus rule issued, the government indicated that they would issue future guidance on these types of issues in common scenarios, but we have yet to see anything from the government other than their settlements, if you want to look and see what kinds of things that they're going after. So, in summary, if you're deciding whether or not a breach of unsecured protected health information is reportable, remember this: there is no breach notification required, at least under the breach notification rule, if there was no privacy rule violation, including incidental disclosures. Remember, incidental disclosures do not violate the privacy rule, and therefore they do not constitute a reportable breach. If the protected health information is secured, meaning that it's electronic and encrypted per HHS standards, then even though you lose the laptop, but if all the data was properly encrypted, then it's secured, so there is no breach of unsecured data, therefore it's not reportable. If one of those exceptions applies, it's the internal disclosures or access or disclosure to someone who can't be reasonably determined to retain the information, then there's no reportable breach. Or if none of those apply, you do the analysis and you conclude that there's a low probability that the data has been compromised, then maybe you conclude that it's not a reportable breach. But remember, you have the obligation, you have the burden of proving that it's not a reportable breach. And the government is always going to look at this, 20/20 hindsight afterwards. So be very, very careful. As I mentioned back at the very first, remember that according to HHS, the following circumstance constitutes willful neglect. If a covered entity's employee lost an unencrypted laptop that contained unsecure protected health information, but you just don't want the adverse publicity or the cost associated with it, and therefore you ignore your breach reporting obligations, guess what? Even though that initial loss of the laptop may not be willful neglect, if you refuse to do the breach report, that is willful neglect, and you can get hit up with all those fines or penalties. So, until we receive further clarification, I think it's simply safer to err on the side of reporting all but clearly inconsequential breaches. Remember, you have the entity approving a low probability that the data has been compromised, and the government will take a critical look at that. The failure to report that may be viewed as willful neglect, resulting in mandatory penalties. The government receives so many breach notifications that they simply haven't got time to respond to all of them. So in the vast majority of situations, if you have an isolated incident, you go ahead and do the breach reporting. It goes in, you submit it electronically, like we'll talk about in just a minute. It goes to the OCR, and it goes into the file that nobody ever looks at again, and it's not a problem. And you're safe. On the other hand, if you fail to make the report, the patient learns about it, they turn you in, then the government can get really upset with you and impose those mandatory fines or penalties. A word about unencrypted data, the loss of that. The government assumes that the loss of an unencrypted USB, unencrypted laptop, unencrypted mobile device that contains protected health information, that is presumed to be a reportable breach. And you're going to have to do the breach report. And remember, every person whose data was on that, that's a separate potential breach. It is a huge issue. That's where those multi-million-dollar damages cases are coming out of when you've got the big HIPAA fines or penalties. You want to make sure that you encrypt your data on your electronic devices. If you're not, then you're really just playing Russian roulette with HIPAA, and once you lose that, you're going to have to give the breach report, and the government can come in there after you if you didn't have the and tag you for failing to properly encrypt or take other appropriate steps. So be very, very careful with your mobile devices, laptops, and unencrypted data. All right. So let's say you've gone through that analysis and you have concluded that there is a breach of unsecured protected health information. It's reportable. Then what do you need to do? If you're a covered entity, you've got to notify each individual whose unsecured protected health information has been or is reasonably believed to have been accessed, acquired, used, or disclosed. If you, in addition, you're going to have to notify HHS. The only difference is the timing. If the breach involves more than 500 persons in a particular state, you're going to have to also notify local media. If you are a business associate, you're going to have to notify the covered entity, who likely will not be very impressed with your business associate services. As far as the timing, you've got to provide the required notices if you're a covered entity without unreasonable delay and in no case later than 60 calendar days after discovering the breach. As I mentioned earlier, you are deemed to have discovered the breach the first day your workforce member or agent, other than the person who committed the violation, knew or should have known of the breach. It does not run from the time that the privacy officer learns about it. It runs from the time that the person in the cubicle next to the violator learned about it, or anybody else in the organization except the violator. Note also that that 60 days is the absolute outside time. The government says that you are obligated to respond and provide the notice as quickly as possible, and in no event longer than 60 days. That means if you can investigate and conclude the scope of the breach and make the report within 10 days, you're supposed to make the report in 10 days. You do not automatically have 60 days. The net effect, again, make sure that you train your workforce to report breaches promptly, and you require your business associates to report promptly. The breach notification rule only requires the business associate to report it within 60 days. Well, if that business associate is determined to be your agent, then that may be, your 60 days may have run by the time the business associate gives you the notice. You'd ought to really include provisions in your business associate agreements that require the business associate to notify you in a shorter time period, say within 5 business days, just to make sure that you can respond appropriately and get the benefit of those prompt reports. Well, what do you have to provide to the individual if you're doing notice? You've got to provide a brief description of what happened, including the dates of the breach and the discovery, a description of the types of unsecured protected health information that was involved, the steps you took to, the steps that that person should take to protect themselves from harm resulting from the breach, whether that's doing credit checks or whatever, a brief description of what you are doing to investigate, mitigate, and protect against future breaches, and the contact procedures to ask questions or learn information, including a toll-free phone number, email address, website, or postal address that they can contact you to get more information about that particular breach. You've got to provide that notice to the individual by first-class mail to their last known address. Even if the patient is the one who reports the breach, they're already aware of it, the government still says you've got to send them the breach notice, even if they're aware of it. I guess this is the government's way of ensuring that the U.S. Post Office stays busy because you've got to send that by first-class mail. If the individual is deceased, you've got to provide that information to the next of kin if you have their address. In urgent situations, you may also contact the patient by phone or other means, but you've still got to send a written notice. You can send the notice by email if the patient agrees that you can send the notice by email. If you lack sufficient contact information to provide the written notice to the individual, you've got to provide a substitute form that's reasonably calculated to reach the individual. And the type of notice that you provide depends on the number of persons who are affected for whom you do not have adequate contact information. If there's less than 10 such persons, then you may use an alternative form of written notice or by telephone or other means. You don't have their postal address, so you can't send them the letter, but you can call them up. Then you can do that, but you probably want to follow up with a written notice. On the other hand, if there's 10 or more such persons for whom you do not have sufficient contact information, maybe it's a breach of old information, you don't have their current information, then you've got to provide means of the breach by alternative methods. That could include you've got to provide a conspicuous post on the Covered Communities website for 90 days or in major print or broadcast media where the affected individuals are likely to reside, and you've got to include a toll-free number for at least 90 days. That's a real hassle, but nevertheless, that's what you are required to do. All right, that's the notice to the individuals who are affected. Every time you notify the individual, you're also going to have to notify HHS. The only difference is the timing. If the breach involves fewer than 500 persons, you can wait to make the report to HHS until 60 days after the end of the calendar year in which the breach was discovered, i.e. by March 1st, depending on whether or not I guess it's a leap year. So you can wait and make the report later if it's under fewer than 500 persons. My general rule of thumb is, yeah, go ahead and wait, and you, along with the million other people, are all submitting your electronic notices on the same day, February 28th. The government's never going to see them. They can't parse through all that stuff, and yours is going to get lost along with everybody else's. That's my theory. I'm not sure it works, but you will see. On the other hand, if the breach involves 500 or more persons, you should notify HHS, or you must notify HHS at the same time you notify the individual or next of kin. That is, without unreasonable delay, but within 60 days. How do you notify HHS? Well, you do this electronic report. You go to that link that's there in the slides. It will take you to the government's HHS website dealing with health information privacy and HIPAA, and you follow the instructions depending upon the nature of the breach. If the breach involves 500 or more persons, then your name gets added to the wall of shame where the government posts the names of all of those entities who have had a breach involving 500 or more persons. All right, that's the notice to the government. What about notice to media? Well, if the breach involves unsecured protected health information of more than 500 residents in the state, in addition to notifying the individuals and HHS, you've also got to notify prominent media outlets serving that particular state, such as issuing a press release. You've got to notify them without unreasonable delay, but no more than 60 days from the discovery of the breach, and you've generally got to include the same type of content as you do in the notice to the individual, but for heaven's sakes, don't include any protected health information in that notice to the media. Also, note that this only applies if there's a disclosure of unsecured protected health information of more than 500 residents in a particular state. So if you happen to live on a border town and there's 400 residents in state A and 300 residents in state B, there's not 500 persons in a particular state, then you would not have a breach notification requirement. You don't aggregate them all. You look at the number of residents in each state. All right, what about the business associate? Well, the business associate, if it learns of a breach, it's also got to report notify the covered entity so that the covered entity can go ahead and make its report. As I mentioned, under HIPAA, they've got to report without unreasonable delay, but in no more than 60 days from the discovery. The notice shall include, to the extent possible, the identification of the individuals who are affected and other information that is necessary for the covered entity to go ahead and make its breach report. Again, check your business associate agreements because they may and should require different breach reporting time limits. I would always make sure that in my business associate agreements, I required that business associate to report within X days. You may also want to specify the information that you're requiring that business associate to report. Can you extend that breach reporting period because law enforcement asks you to? Yeah, generally you can, but there's requirements depending on whether or not it's an oral request for law enforcement or a written request for law enforcement. All right, that is my overview of responding to HIPAA and how you do the breach notification stuff. Real quickly, let's talk briefly about ransomware because ransomware is a growing problem. As of July last year, hospitals were the victims of 88% of all the ransomware attacks. The majority of ransomware attacks were going against hospitals. Why? Because you are an easy target. Hospitals are easy targets because there are so many data access points. Plus, once that information's encrypted, the hospital, it's got, that stuff's life and death, the information in the hospital system. And quite frankly, it's easier for the hospital to pay off the person who's holding you ransom than it is to fight it. And because of that, they're an easy target. And because they're an easy target, they are going after those, the hospitals are paying, then the persons who are engaging in the ransomware are taking that money to fund future development efforts in order to develop more sophisticated ransomware, and it's a vicious cycle. You have to be concerned about ransomware. 2016, there were a whole bunch of hospitals who were attacked pretty publicly. A bunch of them made news. I'm aware of 3 hospitals in the Intermountain West, just around my neck of the woods, that were hit by ransomware, although they didn't all make the news. That's not going to go away. People think that healthcare is going to be the top target for cyber attacks in 2017. That is really scary stuff. Matt's going to talk more about that stuff in a couple of weeks. He already talked about the security rule a while ago. You may want to go back and listen to that to help protect yourself against cyber attacks. Specifically with regard to ransomware, it is such an issue that the OCR issued specific guidance dealing with ransomware and HIPAA. I've provided you with a copy of that. You really had to take a look at that. Among other things, it talks about how you protect yourself against ransomware through HIPAA compliance, how you identify attacks, and how you're supposed to respond if you do get a ransomware attack. This is the key point I wanted to mention. The government has said that when electronic protected health information is encrypted as a result of a ransomware attack, a breach has occurred because the EPHI encrypted by the ransomware was acquired. The government has taken the position that even though that ransomware is encrypted, it encrypts the stuff, so arguably no one else has disclosed it to anybody else. It's just kept anybody else from looking at it. I took the position that that was not a reportable breach. The government has said, no, we think it is a breach because when that person has come in there and encrypted that information, they have effectively acquired it. They've encrypted all of it. They've accessed it. Even though they may not themselves be able to look at the data, it's still, they think that it is presumptively a reportable breach. Now think about that. You are a hospital, you get a ransomware attack, it's now, under this analysis, the government says that that's presumptively a reportable breach. How many records is that going to affect, and how many patients is that going to affect? That's probably going to be more than 500, so that means you're going to have to do the notification, those very extensive notification requirements to your patients, to the government. You're going to get on the wall of shame, and you're going to have to do the media notifications. That is a huge hassle. It is a huge issue. The government has said it may be possible for you to conclude that even though you got hit with a ransomware attack, that it is not a reportable breach, but you would have to show that there's a low probability that the data has been compromised based on the factors that we talked about earlier, and it will be a hard standard to satisfy. Some additional factors that the government listed in that guidance, I'd encourage you to go back there and take a look at it. The bottom line there is ransomware is ugly, not only for the practical problems, the life and death situations that it may occur, but also because of the HIPAA compliance issues. The best thing to do is to make sure that you implement the required safeguards to protect against ransomware in the first place, and if you are backing up your data as required by the security rule, then you always have the data available so you don't have to worry too much about the ransomware attack. The bottom line is, make sure you're complying with HIPAA. Ransomware is such a problem that there was actually an interagency memo that was published by the federal government last year talking about how to protect your networks from ransomware. You really have to download that and take a look at that, share that with your IT people to make sure that you put in place ransomware protections. Okay, we've talked about the federal laws. What about state laws? Almost all states, perhaps all states, have some type of security breach notification law. Most of these were based on a model law that went around a few years ago. Most of them have these elements. They generally require all commercial entities, not just healthcare entities, these apply to any commercial entities, to immediately investigate and notify persons who are affected if there is a breach of a computer system resulting in illegal acquisition of certain unencrypted computerized data. That data normally has to have the patient's or the person's name along with certain other identifiers, whether it's social security number, license, credit card, etc. And if there's a potential for actual or reasonably likely misuse of the information. This is not just a healthcare law. This applies to any data that you have. It could be about your own employees. It could be about patients. It could be about anybody. And it applies not only to healthcare entities, but all entities that are out there. Chances are, what this does is it requires you to make that report to the affected individual. Sometimes it requires you to report to the AG. If you fail to do so, you can get hit up with fines or penalties. That's kind of the way this thing works in most states, but you need to check your own state laws for any additional or variations on that or additional state laws that may apply. As I mentioned, some states have more draconian privacy laws, particularly California and Texas. You need to make sure you're aware of those laws. So, in summarizing, if you think you have a breach, act immediately to minimize the breach, notify your privacy officer. The privacy officer should then take over and confirm whether HIPAA even applies, confirm if it does apply, whether HIPAA was violated, check on insurance, investigate promptly, take appropriate steps to mitigate any harm, sanction workforce members, correct any process that resulted in the improper disclosures, log the improper disclosures to the extent required by the HIPAA accounting rule. If you are going to have to report the breach to the covered entity, and or if you're a covered entity, report the breach to the individuals in HHS, then make sure to do it in a timely fashion and document the foregoing. Remember, if you act promptly to a suspected HIPAA violation, you will satisfy your duty to mitigate. You may be able to avoid disclosing and breach reporting obligation if you're able to sufficiently contain the problem. And if nothing else, you're going to be able to defend against HIPAA penalties because you corrected the situation within 30 days. When it comes to responding to possible HIPAA violation, remember, an ounce of prevention is really worth a pound of cure. That's why it's so important to minimize your HIPAA exposure before a violation occurs. Make sure that you know the HIPAA rules, that you implement the required policies and safeguards, all of those things that we've been talking about this past month. We've got those webinars available for you. We've got a lot of written materials for you. You can access those or use them for your own training. One of the reasons we did those is so that you could use them to train your employees. You can minimize your exposure if you train your employees regarding the policies and safeguards. Make sure that you execute confidentiality agreement and business associate agreements. Respond immediately to a suspected breach, and you document all of the foregoing. If the OCR does show up to investigate, which is fairly rare these days just because they're so busy, you may want to consider contacting a knowledgeable healthcare attorney who can walk you through the HIPAA analysis. If they show up, cooperate with the OCR. Your most important asset is your credibility, so you want to cooperate, but be careful what you disclose. Just so you know, one of the biggest HIPAA fines today was about $4.3 million against an entity. It was based not because of an improper breach, but because of the entity's failure to allow patients to access their information. They got hit up for $1.3 million for failing to allow the patient to access the information. They got hit up with an extra $3 million for failing to properly respond to OCR during the investigation. So if the OCR shows up, make sure that you respond in the appropriate way. During the investigation, explain your position to the OCR in the response, including explaining that you had appropriate policies in place, that you had the appropriate training, and you just had a rogue employee, that they violated the policies and training, that you responded immediately and appropriately to mitigate any harm, that you've taken corrective actions. If you've done that, you can almost certainly establish that there was no willful neglect. You corrected it within 30 days, and you can avoid any HIPAA penalties. All right, if you're looking for additional resources, again, the government has great resources on its HIPAA website, hss.gov. HIPAA, if you want to access that, just Google OCR and HIPAA. It will take you there. Look under the HIPAA for Professionals tab, and that gives you a whole bunch of stuff. In addition, on our website, I like HIPAA a lot, so I do a lot of writing on HIPAA. I've got a lot of practice guides, a lot of checklists, articles, things like that. You can access it. It's all free. As far as upcoming Holland and Hart webinars, in March, my colleague, Matt Sorensen, is going to be talking about cybersecurity issues. Feel free to tune in there. Again, these webinars are all free. If you would like to access them, any of the current ones or past ones, you can go and access those on the website. If you would like to get information about our upcoming webinars, shoot me an email. That is it. Thanks very much. I hope this series about HIPAA has been helpful. Feel free to, if you have questions, shoot them to me offline or use the chat feature, and I'll go ahead and respond to those as quickly as I can. But thank you very much, and I hope you guys have a good day.